to go. All right. Good afternoon, everybody. I would like to welcome you all to the Ethics Commission's fourth and final webinar of 2024, Dakota Dilemmas, Lobbyist Gifting, Naughty or Nice. We took a bit of a break since our last Dakota Dilemmas webinar to prepare for legislative session in our office. But today we are back to talk about lobbyist gifting rules before we all move into the 69th legislative session in January. Thank you all for taking time from your schedules today to join us and continue to learn about state ethics laws through this Dakota Dilemmas webinar series. I want to especially thank those of you who've joined us for our previous sessions this year, which explored historical ethical conflicts in North Dakota, how to manage ethical conflicts using the Commission's rules, and how the Commission's complaint process works. My name is Rebecca Binstock, and I have the privilege to serve as the Executive Director for the North Dakota Ethics Commission. With me today is Logan Carpenter, who serves as General Counsel for the Commission. Mr. Carpenter and I will be co-hosting our webinar today. The Dakota Dilemma webinar series was born from both the Ethics Commission and the legislature's recognition of the need for education about the Commission and how it meets its constitutional obligations. So again, I want to thank everybody for joining us today. Our webinar today shares an overview of the Commission's work with the purpose to educate both those regulated by the Commission and the public. Our webinar will not address specific situations or circumstances that may arise for specific individuals, but we will explore some hypotheticals that may or may not be holiday themed for you to practice what you have learned. During our previous webinars, we explored the history of ethical conflicts in our state, how these rules, how Ethics Commission rules help public officials manage conflicts of interest, and an in-depth look at the Commission's complaint process, as I previously said. As gifting is in all of our minds during the holiday season, with the holidays quickly approaching, today we are going to explore the Commission's rules surrounding lobbyist gifting, which means gifting between lobbyists and public officials. Please feel free to drop questions you may have into the chat along the way. We'll then review those questions during our question and answer session near the end of our time together. During our previous webinars, we utilized polls to solicit responses from participants. We plan to do that again today. That's how we're going to help you guys test your knowledge to date. Please know that that polling function may not work on all devices. Depending on your device settings, you may not be able to submit a response, which is perfectly okay. Those are not graded. With that, let's pick up where we left off from our last webinar and explore the Commission's rules surrounding gifts between lobbyists and public officials. So let's start with an agenda for today. So our focus today is very limited, but we're going to get into some really good information. Our focus is going to be on the Commission's lobbyist gifting rules. So in 2020, the Ethics Commission adopted rules regarding gifts between lobbyists and public officials. They were directed to do this pursuant to or under Article 14 of the North Dakota Constitution. So because that's where that authority comes from, we're going to start there today. We're going to start by looking at North Dakota Constitution Article 14, how it was created and how it created the Ethics Commission. We're then going to talk about what we call the constitutional prohibition. This is the baseline gifting prohibition rule that was created in Article 14 of the Constitution. We're then going to turn our focus to Commission-created exceptions. Article 14 of the Constitution directs the Commission to craft exceptions to the gift prohibition. So we're going to walk through in great detail what those exceptions are that have been adopted by the Commission. And last, we're going to talk about potential or possible penalties and then also remedies if there is a violation of a gifting prohibition. What are the consequences, and how can an individual potentially remedy that situation quickly? So let's start with our constitutional amendment. Now, some of this we did recap in our last webinar. It really is the foundation for the North Dakota Ethics Commission. So we usually start, for those of you who are new, with just this quick review. So we're going to start here. In 2018, there was a citizen-initiated ballot measure sponsored by the North Dakotans for Public Integrity, and they put Measure 1 on the ballot. Measure 1 created Article 14 of the North Dakota Constitution. In Article 14, there was the establishment of an independent state ethics commission. Voters passed the measure, and therefore Article 14 of the Constitution was added. North Dakota joins 47 other states that have an independent ethics commission or equivalent. Only 2 states do not have an independent government office dealing with ethics. Those are going to be Idaho and Wyoming. So after we had the ballot initiated measure in November of 2018, we had the 2019 legislative session. This is going to be our 66th legislative session. The legislature during that session passed legislation for the commission, and it set out some procedures for the commission, but it also created certain penalties for Article 14 of the Constitution. Article 14 of the Constitution directed the legislature to do that. We're going to talk about some of those penalties today. Other penalties that we're going to talk about or that were created at that time were penalties for lobbyist gifts. We're going to talk about that one. Also penalties for lobbying by public officials after their term of service has ended, and lobbyists delivering campaign contributions. Those penalties were outlined in 2019. Also in 2019, the commission had its first members appointed. The Constitution requires that there are 5 members of the Ethics Commission, commissioners. They are appointed by consensus agreement of the governor, Senate Majority Leader, and Senate Minority Leader. Commissioners cannot be lobbyists or other state public officials. Commissioners can be removed in the 2019 legislative session. This was laid out. Commissioners can be removed by a majority vote of the governor, Senate Majority Leader, and Senate Minority Leader for substantial neglect of their duties, gross misconduct, a violation of the Commission's Code of Ethics, or willful or habitual neglect in their duties. So let's talk. We've had a recent change to members of the Ethics Commission. So we have our current commissioners. Our chair is Dave Anderson of Bismarck. We have our vice chair, Ward Kozer of Williston. We have Commissioner Ron Goodman from Oaks and Commissioner Dr. Cynthia Lindquist of Devil's Lake. Our newest addition is Commissioner Murray Sagsveen of Bismarck. He was recently appointed in September to replace our past chair or previous chair, Paul Richard of Fargo. 4 of our current commissioners are the original part of the original 5 commissioners, and they've all been appointed to serve a second term, with Mr. Sagsveen being on his first term. The mission of the North Dakota Ethics Commission, which was established in 2019, shortly after the commissioners were appointed, is to strengthen the confidence of citizens of North Dakota in their government by ensuring and promoting transparency and accountability. In Article 14 of the Constitution, the Ethics Commission gets its 2 foundational constitutional directives. One of those is to adopt ethics rules related to what we call our 4 buckets: transparency, corruption, elections, and lobbying, to which any lobbyist, public official, or candidate for public office shall be subject to. The second directive that Article 14 of the Constitution gives the Commission is to investigate alleged violations of the Commission's rules, Article 14 of the state constitution, and related state laws. That second directive that the Commission gets to, we focused on that in our previous webinar. What we're going to talk about today is one of the rules that was adopted pursuant to the Commission's authority to adopt rules. So let's talk about the rules that we're going to talk about today and the other ones the Commission has adopted thus far. Since the commissioners were originally appointed in mid-2019, the Commission has established rules related to its complaint process, which we've already talked about in our previous webinar, lobbyist gifting, the topic of today, the appearance of bias in quasi-judicial proceedings, and conflicts of interest, also part of our previous webinars. So the complaint rules were the first set of rules adopted, and those were adopted in 2020. These describe the process for filing and investigating a complaint. The Commission previously hosted a webinar and we focused on complaint rules. That webinar is available on our website. Lobbyist gift prohibition rules were adopted also in 2020. These describe which gifts are prohibited from lobbyists to public officials, and then it also describes exceptions to that prohibition on gifting. That's the focus of our webinar today. The other two rules or types of rules, groups of rules that were adopted by the Commission to date is an appearance of bias rules in quasi-judicial proceedings. These were adopted in June of 2022. These rules address how individuals manage the appearance of bias in quasi-judicial proceedings in our state. Last, the Commission adopted general conflict of interest rules in October of 2022. These rules help public officials manage potential conflicts of interest that come up in their work and in their decision making. Both the rules affecting appearance of bias in quasi-judicial proceedings and the conflict of interest rules are were also the subject of a previous webinar that we hosted, and that information is available on our website. The Commission is currently discussing both travel and financial disclosure statement rules for public officials, and they are working with the legislature on potential legislation in this area. But for the purposes of today, we are going to focus on understanding the language and understanding Chapter 115.03.01 of the North Dakota Administrative Code, entitled Gifts Between Lobbyists and Public Officials. This is the set of rules adopted by the Commission back in 2020. There have been a few amendments. So as the Commission adopted these rules and the other rules that it has adopted, let's talk about that rulemaking authority. The Ethics Commission is constitutionally authorized to adopt ethics rules, as I previously said, related to what we call our 4 buckets: transparency, corruption, elections, and lobbying. What does that mean to have that constitutional authorized or authorization to adopt rules? So when the Commission was considering its gift rules in 2020, the Commission requested an Attorney General opinion when it was defining the term lobbyist, essentially asking whether the Commission could define the term lobbyist broader in its rules, in the Commission's rules, than the already present statutory definition of lobbyist that's contained in North Dakota Century Code 5466.01 subsection 8. They wanted to enact a definition or have a definition that worked with rules that they would adopt in order to give effect to the language of Article 14. The definition of lobbyist contained within the Century Code was very limited to legislative lobbying, and the Commission's work was broader than that. In Letter of Opinion 2020-L-09, the Attorney General opined that the Commission has constitutional authority to adopt a rule defining the term lobbyist in its proposed rules, and it may be more expansive than the statutory definition of a lobbyist. This is going to become very important in our discussion later during this webinar. The opinion noted that statutory ethics rules, meaning definitions, etc., and ethics commission ethics rules should be read in harmony when possible. When possible means when it's reasonable and workable. However, if the rules can't be harmonized or conflict, the constitutionally authorized rule prevails, meaning the Ethics Commission's rule prevails. The Attorney General opinion was based on the North Dakota Supreme Court's reasoning in City of Fargo versus Ruther. In City of Fargo versus Ruther, the North Dakota Supreme Court analyzed whether a statutory provision which limited the admissibility of an alcohol level evaluation roadside tester conflicted with the rules of evidence adopted by the North Dakota Supreme Court. The North Dakota Supreme Court has constitutional authorization to adopt rules of procedure to be followed by all courts in the state. Ultimately, the court concluded the legislatively enacted rule could be harmonized, goes back to that attempting to harmonize with the constitutionally enacted rules. But in City of Fargo versus Ruther, the Supreme Court said, but if the statutory rule engulfs the constitutional rule or is in direct conflict, the constitutionally promulgated rule prevails. Both the AG opinion and the supporting case law provide a basis for how the Ethics Commission adopts and potentially harmonizes rules with other statutes and rules. So let's briefly talk about the rulemaking process for the Ethics Commission. The Ethics Commission is an independent ethics commission, meaning that we're not part of any other branch of government. The commission is not an administrative agency, it's an independent constitutional entity. The Ethics Commission's rulemaking authority, as we previously said, is constitutional, and it's derived from Article 14 of the Constitution. This is distinctly different than the source of authority that flows to administrative agencies, which is delegated to agencies by the Legislative Assembly. Therefore, because of this distinction, the rulemaking process for the Ethics Commission is slightly modified from the rulemaking process for administrative agencies. In North Dakota Century Code 546611, it outlines how the Ethics Commission, or what portions of the Administrative Agencies Practice Act, the Commission needs to follow. It specifically will use the term agency or commission. So the portions of the Administrative Agencies Practice Act, which specifically apply to the Ethics Commission, include language referencing the Ethics Commission. Typically, a rule that applies to an administrative agency and the Ethics Commission includes both the terms agency and commission. The Ethics Commission is subject to the regulatory analysis requirement in the Administrative Agencies Practice Act, the fiscal impact statement requirement, the takings assessment requirement, the hearing, notice, comment, and publication requirements of the Administrative Practices Act. However, portions of the Administrative Agencies Practice Act do not apply to the Ethics Commission. And this is because, unlike administrative agencies, commission rules are from the Constitution. So commission rules are not reviewed by the Attorney General or the Legislative Administrative Rules Committee before final adoption. These provisions are inapplicable because the Legislative Assembly does not delegate that rulemaking authority to the Ethics Commission in the way it delegates authority to administrative agencies. So, what process does the Commission follow when it adopts rules, such as the rule we're talking about today, which is the lobbyist gifting prohibition and exceptions? So what we end up with is a modified process from the administrative agency or an administrative agency's process. So first, the Commission prepares and finalizes a proposed rule. It then provides notice to the public through publication that goes out in newspapers. We also publish all of that on our website. We then have a comment period. We have a particular comment period and the commission receives comments. We then have a public hearing. The commission then responds to comments and eventually has final approval. Now, although the Ethics Commission is not an administrative agency, publication of the Ethics Commission rules is done in North Dakota Administrative Rules, Chapter 115. So with that kind of background knowledge of how we got to where we get today with our rules, I'm going to hand it over to Logan to talk about the baseline rule of the Constitution.
Thanks, Rebecca. So to start talking about the lobbyist gift prohibition, we need to go back to Article 14 of the North Dakota Constitution. Article 14, Section 2, subsection 1 states, a lobbyist may not knowingly give, offer, solicit, initiate, or facilitate a gift to a public official. A public official may not knowingly accept a gift from a lobbyist. These prohibitions do not apply if the lobbyist is an immediate family member of the public official. Gift is also defined in the Constitution and means any item, service, or thing of value not given in exchange for fair market consideration, including gifts of travel or recreation. So what does this mean? In general, this means lobbyists cannot give anything of value to a public official. The Constitution prohibits it. The lobbyist gift prohibition took effect in January of 2021 to allow the Commission 2 years to adopt rules. So let's break down two of those terms that are used in the lobbyist gift prohibition from Article 14. The first one being, who is a public official? The Constitution provides the definition, and it includes elected or appointed members of the executive and legislative branches, members of the Ethics Commission, and legislative employees. Examples include statewide elected officials like the governor, the treasurer, the secretary of state, our public service commissioners. It also includes legislators, members of the governor's cabinet, and members of boards and commissions, among other individuals. It does not include executive branch employees. It also does not include local city or county officials. It does not include members of the judicial branch. So now that we know who is a public official, who is a lobbyist? In its gift rules, the Commission defines the terms lobby and lobbyist slightly broader than a registered lobbyist in the Century Code. So who is a lobbyist for purposes of the gift rule? Anyone who is required to register as a lobbyist under North Dakota Century Code Section 54-05.1-03. This applies to any person who in any manner whatsoever directly or indirectly performs any of the following activities: attempting to secure the passage, amendment, or defeat of any legislation by the Legislative Assembly, or the approval or veto of any legislation by the governor. It also includes people who attempt to influence decisions made by the legislative management or by an interim committee of the legislative management. The gift rules also include a person who attempts to secure passage, amendment, or defeat of any administrative rule or regulation by any department, agency, or body of the state's executive branch, or someone who attempts to otherwise influence public official action or decision. Those two criteria are the distinct difference between the lobbyist definition in the Century Code and the lobbyist definition in the Commission's rules. The Commission's expanded definition mainly focuses on when lobbying occurs outside the legislative process. So who is not a lobbyist? There's quite a few exclusions. And that includes a legislator, a private citizen appearing on the citizen's own behalf, an employee, officer, board member, volunteer, or agent of the state or its political subdivisions, whether elected or appointed, or whether or not compensated, who is acting in that person's official capacity, A person invited by the chairman of the legislative management, an interim committee of the legislative management, or a standing committee of the legislative assembly to appear before the legislative management, interim committee, or standing committee for the purpose of providing information. And finally, an individual who appears before a legislative committee for the sole purpose of presenting testimony on behalf of a trade or professional organization or a business or industry if the individual is introduced to the committee by the registered lobbyist beforehand for the trade or professional organization or the business or industry. So now that we know who is a lobbyist and who is a public official, let's get into the exceptions for that broad lobbyist gift prohibition. The Constitution specifically authorizes the Ethics Commission to make certain exceptions to that broad prohibition. Under Article 14, gift does not mean any purely informational material, campaign contribution, or in order to advance opportunities for North Dakota residents to meet with public officials in educational and social settings inside the state, any item, service, or thing of value given under conditions that do not raise ethical concerns, as determined by rules adopted by the Ethics Commission. That's quite a bit of information there, so we'll break it down as we go through here. But Article 14 gave the Commission 2 years to adopt these gift rules. The Commission adopted the rules in October of 2020. So let's break it down. Following the constitutional directive, the Commission set certain exceptions to the general lobbyist gift prohibition. The exceptions mainly focus on providing food at the receptions, dinners, meetings, etc., that were a common occurrence prior to the creation of the Ethics Commission. The Commission's rules recognize 3 events where an exception applies. On this slide, we're going to talk about 2 of them. Keep in mind the Commission's exceptions do not apply out of the state of North Dakota. These exceptions only apply in-state. So the 2 main events are, first, a public, social, and educational event. That would be any social and educational event that is held within North Dakota, and attendance is open to any state resident and others. The second one, and a more common occurrence, is a private, social, and educational event. This is any social and educational event that is held within the state, and attendance is by invitation to state residents and others who are members, employees, or affiliated with the sponsoring public or private organization, entity, or association. At both types of events, it cannot only be public officials and registered lobbyists in attendance. The event needs at least one non-lobbyist/non-public official to also be there. So what is allowed when you host a public, social, and educational event, or when you host a private social and educational event? First, food and beverage served for immediate consumption is allowable. However, you cannot offer bottles of wine, treats, cake, etc. to take home after the event. It has to be immediately consumable at the event. The second exception is gifts or other things of value shared as a cultural norm. The most common example is a star quilt that's sometimes given by our tribal nations or gifts between dignitaries. The third exception is transportation, lodging costs, and meal costs for these events within the state when the public official is meaningfully participating in the event as a speaker or panel participant, a presenter, or a ceremonial event appropriate to the position, or if attendance is appropriate to their performance of official duties. The payment has to comply with the state rates, which can be found in Office of Management and Budget Fiscal Policy number 505. So what does this exception mean more specifically? If the public official is being reimbursed for transportation, lodging costs, and meal costs to attend the event, they must also be working at the event beyond being a participant that is there to learn and eat. So now that we know these events are allowable, let's talk about the educational component that's needed. Again, both types of these events require an educational component, and they must not be limited to a social event. So what does that educational component entail? The Commission received a request for an advisory opinion that addressed that issue specifically. In Advisory Opinion 22-02, the Commission said an educational component of a private or public social and educational event should serve to inform the public officials about a topic, issue, or problem and provide helpful and thorough review of the topic, issue, or problem based upon the unique knowledge, skills, or research from the lobbyists. As a best practice, the Commission encourages presentations outlining the topic, issue, or problem with analysis by the lobbyist or the group the lobbyist is working on behalf of. So now that we've talked about the educational component, let's talk about that other requirement, the event notice. The Ethics Commission's rules require event sponsors to file a notice with the Commission prior to any public or private educational and social event. The Commission's rules specifically state the Commission does not approve events. If you're concerned about attending a certain type of event or hosting a certain type of event, please request an advisory opinion well in advance to allow the Commission sufficient time to weigh in. The Commission is aware of instances where it is advertised the Commission has approved a certain event. The Commission does not meet often enough or have adequate resources to review and approve events ahead of time, especially when they're on short notice. So that is the reason why the Commission has specifically said it does not approve events. There's one more event that we haven't talked about yet, so let's talk about it now. That's informal events. The Commission recognized on certain occasions, lobbyists may meet with individuals and public officials on an informal basis to provide education. So the third event recognized by the Commission's rules is that informal social and educational event. This is any meeting, session, or interaction occurring within the state between a public official and a state resident, including but not limited to a registered lobbyist who is a state resident, for the purpose of informing or educating the public official on a matter of interest or concern. So what is allowed at an informal social and educational event? These events can be a one-on-one gathering, like going to grab a bite to eat for lunch, because food or beverage with a value of $10 or less, excluding gratuity, is allowable. It must be again consumed during the event and cannot be taken home following the event. Must be for immediate consumption. The lobbyist can purchase the $10 food or beverage item for the public official. And no prior notice with the Ethics Commission is required for the informal social and educational events when they are limited to $10 for food and drink. So those are the 3 event exceptions, but there's also some additional exceptions we should talk about. The first one being a gift by a lobbyist who is a member of the public official's immediate family. This is explicitly excluded from the definition of a gift in Article 14 of the Constitution. The second exception in the Commission's rules is any item given where the public official is paying fair market value for the item. The third one is purely informational material. These are your handouts, your pamphlets given to certain public officials, maybe at one of the events, but they are excluded from the gift prohibition. And the fourth one is a campaign contribution that is given in accordance with all applicable state laws, rules, and regulations governing campaign contributions. So the Constitution allows the Commission to create exceptions in state. Those exceptions apply in state only. There are no exceptions to the lobbyist gift prohibition outside of North Dakota because the Constitution does not allow the Commission to create one. This was the issue in Advisory Opinion 23-02 issued by the Commission. The Commission said, again, the exceptions for private and public social and educational events do not apply outside of North Dakota. Therefore, the baseline constitutional prohibition of gifts between lobbyists and public officials applies. So when there are events out of the state, there are 2 questions that need to be answered. 1, whether the travel expense or item accepted outside of North Dakota is a gift, and 2, whether the gift is given in conjunction with an effort to lobby. In that advisory opinion, the Commission concluded travel expenses are unquestionably gifts. to answer that first question. To answer whether the gift is given in conjunction with an effort to lobby, the Commission recognized activities and efforts that may be considered lobbying fall within a spectrum of activity. One type of out-of-state event is an objective educational conference to continue education, provide professional development, or vocational training. The Commission said these events are unlikely to be considered lobbying because they are aimed at providing education only. Another type of event are those objective. Individuals preparing materials, presenting materials, or engaging in discussions at an event may align with a particular agenda. That information is then presented through a filter that is aligned to that agenda, with opposing views excluded. The Commission said these events need to be evaluated on a case-by-case basis. And the Commission said when reviewing these types of out-of-state events for whether lobbying is occurring, public officials can consider 5 factors, and the Commission laid out the 5 factors in the advisory opinion. The first one being the overarching objectives of the event sponsor. The second one, topics of the presentations, panel discussions, or social occasions at the out-of-state event. The third one, scope and type of invitees to the event. The fourth, materials provided to a public official before, during, and after the out-of-state event. And 5, communications received by a public official before, during, and after the out-of-state event from the event sponsor or other invitees. All those 5 factors go into the analysis of whether lobbying has or is going to occur at the event, the out-of-state event. One more type of out-of-state event are those which clearly attempt to persuade or influence public official action or decision. In the advisory opinion, the Commission noted these might be when a public official attends an out-of-state event and is presented with scripted or suggested legislation to bring back to North Dakota. The Commission concluded lobbying as defined in its rules can unquestionably occur at these types of events. Ultimately, with out-of-state events, it is the responsibility of the public official to determine whether there is an attempt to influence official action or decision when travel expenses are accepted for those out-of-state events. If the public official or lobbyist would like the Commission to weigh in on these types of events, an advisory opinion request can be submitted on the Commission's website. So now that we've walked through the gift rules, let's do a quick recap and test your knowledge. The baseline foundation is the no gifts between public officials and lobbyists. A lobbyist cannot give a gift to a public official. The Ethics Commission's exceptions apply only in state. At social and educational events within the state, food and drink must be for immediate consumption only, and an educational component must also be present. If a public official is accepting reimbursement by a sponsor, the public official must be working at the event beyond being there to attend, to learn, and to eat. So let's test your knowledge with a poll. Let me bring it up here for you. Now this may not work on all your devices, so if it doesn't, just answer in your head and we'll go over it together. But poll 1 is Hermie the elf, who is a lobbyist for a group of dentists, his clients, and public official Cindy Lou Who have lunch to discuss challenges of a dentist and dental hygienist workforce shortage in North Dakota. Hermie's clients pay for the meal. Is this permissible? Answer A. This is acceptable under gifting rules because the dentists are not registered lobbyists. Answer B. This is acceptable under the gifting rules so long as it is in North Dakota. Answer C. This is acceptable under the gifting rules so long as Cindy Lou Who's meal was $10 or under. Go ahead and submit your answer. I will give you a minute or two to do that, and then we'll review it. Give you a few more seconds if you want to submit your answer. Names aren't recorded, so feel free to answer with your best guess too. Okay, let's close the poll and see the results. So 8% of you said A, 3% of you said B, and 89% of you said C. The majority takes it. The correct answer is C. Under the gifting rules, Hermes clients can be considered lobbyists if they are trying to influence Cindy Lou Who's official action, even though they are not registered lobbyists. However, the situation can fall under the informal social and educational event exception, and therefore the $10 limit applies to that event. We have another poll question. I will turn it over to Rebecca to ask that one to you.
So you should see a second poll pop up. Poll 2, public official Ralphie Parker is attending a nonprofit's holiday gala in Rame, North Dakota to present a major award and speak. Notice was filed with the Ethics Commission, and the nonprofit's director is presenting on the nonprofit's accomplishments and challenges over the past year. What can public official Ralphie accept when he attends the event? A, nothing. B, food and beverage offered at the event. C, food and beverage offered at the event, transportation and lodging costs limited to state rates. Or D, food and beverage offered at the event, transportation, lodging costs, and a fragile leg lamp as a speaker gift. So let's see what you have to say. We'll give you a few minutes to respond. Okay, we'll give you guys just another few seconds to answer this poll question. Okay, so let's close the poll. So it looks like it's a close one between B, food and beverage offered at the event, and C, food and beverage offered at the event, transportation, lodging costs, but limited to state rates. So the answer is C. Because public official Ralphie participated in the event and was not solely there as an attendee, he can accept transportation, lodging costs, and meal costs not to exceed the state rate. And that state rate is set in OMB policy number 505. However, he cannot accept the fragile leg lamp. All right, so in these instances, now that we've walked through our baseline rule and what the commission created exceptions are, let's talk about what happens if a public official inadvertently or mistakenly accepts a gift. a prohibited gift. So the commission in its rules recognized that this may happen, that at times public officials may inadvertently accept a gift from a lobbyist. So the commission built in mechanisms to help the public official remedy such a situation. So what the commission said in its rules is that the commission will not find a violation of the gifting rule or that gifting prohibition if one of two things happened after the gift was received. One, the gift is not used and the public official returns the gift within 10 days after either receiving it or learning that the gift is prohibited. Alternatively, the commission has a second mechanism for remedying this situation. Two is if the public official pays fair market value for the gift within 10 days after either receiving it or learning that the gift is prohibited. So that is nice because there is this ability, this 10-day limit to hand something back or pay for something if needed. So let's talk about our civil penalties, which we equate to getting some coal in your stocking during the holiday season. So one of the common questions the commission receives is, all right, so there's been a violation of the gifting prohibition. What happens? What's the consequence, right? In Section 2 of Article 14 of the Constitution, the Constitution directs that the legislature set both a criminal and civil penalty for when a lobbyist gives or offers a public official a gift, and for when the public official accepts a prohibited gift. There is currently no criminal sanction for lobbyists giving a public official a gift or a public official receiving or accepting a prohibited gift. That has not been set by the legislature. But the civil penalty for a gifting violation was set during the 2019 legislative session. These civil penalties are outlined in North Dakota Century Code 546603, and then in the Commission's rules in North Dakota Administrative Code Section 115-03-01-02, subsection 3. So the Ethics Commission in this instance is authorized to assess a civil penalty. The civil penalty assessed by the Ethics Commission may be as much as 2 times the value of the gift. However, this is not a shall, this is a may. In other words, the Ethics Commission has some discretion in assessing this penalty, and it can consider both aggravating and mitigating factors when assessing that penalty. So with that, let's turn to questions that you may have. So now we've outlined what our statutory baseline rule is, what some exceptions are when things are allowable, and then we've talked about the remedy or how you can potentially remedy something if it happens inadvertently where a public official accepts a gift. And we've also talked about the civil penalty that can be attached to this sort of ethical violation. Now, before we get to questions that you may have, you can go ahead and drop those in the chat. It looks like there's a few of them in there. We'll go and look at those. We wanted to let you know that the slides and the recording from today are going to be made available early next week. You should receive an email with a link to the recording. It will be a link to our YouTube channel for this webinar. Also, this webinar will be available on our website eventually. That takes a little bit longer. And I want to make a plug for advisory opinions. If you have questions about the application of the Commission's rules to a particular circumstance, to your situation, the Commission has authority to issue an advisory opinion to address most circumstances. So if you're interested in requesting an advisory opinion, if you're not quite sure, you can go on the Commission's website and you can request an advisory opinion. I'm also going to make a plug at this point for the updated FAQ, frequently asked questions section on the website, that maybe your question is answered there, and you can look in that section as well. So with that, we have just a few minutes. It looks like we have about 7 minutes according to my watch for questions. So let's go to the chat and see what they are. And I'm going to pull up my chat and I'm going to ask Logan the questions, except now my chat has closed. All right. So the very first question that we got, so I'm going to ask the question to you, Logan, is can a lobbyist receive a gift from a public official?
Yes, the constitutional prohibition is from a lobbyist to the public official. So when the public official is on the receiving end, it does not say anything about when the lobbyist is on the receiving end
Right. So that is not encompassed in the rule.
in the
In
Constitution.
the Constitution. Yes. Okay. And then the second question, thank you for that answer. The second question is, why is the judicial branch excluded? We talk about the definition of public official. Why is the judicial branch not included there?
So the judicial branch isn't included because they are excluded from Article 14 of the Constitution. The Ethics Commission has jurisdiction over public officials and the legislative and executive branches. The reason they may have been excluded is because the judicial branch has its own committees for both judges and attorneys dealing with ethics in the legal profession. So the Ethics Commission would essentially be double regulating if it had authority there. So that's why it doesn't regulate the judicial branch.
Yeah. Okay, thank you for that explanation. That's always helpful. Always flows back to the Constitution, doesn't it?
Absolutely.
It does. Okay, so next question that we have is, does the definition of gift encompass an award?
It can, if there's a thing of value, that could include an award. It depends what the award looks like. Is it recognition or is it a physical thing for the person to take home?
I.e. a fragile leg lamp, if that was the major award.
Or a fragile trophy of some sort.
There is a difference there. Okay. Let's move on to the next question. If a lobbyist does offer a gift to a public official, do the rules say anything about the public official's obligation?
So the Constitution obligates the public official to not accept the gift in the first instance. If it's offered to them, the commission says you should not accept that, but if you do, then you have the opportunity to pay for it or to return it.
Yeah. So let's talk about the word offer, because when we talk about lobbyist gifts, it's not just the giving of the gift. It is actually the offer of the gift that can be a violation. So there's both of those are included. The public official does not have to accept the gift in order to have an ethical violation.
The lobbyist could engage in an ethical violation even if the public official does not reciprocate or receive the gift and also engage in that violation.
But it is knowingly.
It is
right.
knowingly.
It's knowingly offered. So we'll give you guys just maybe another minute or two. If you have any questions, other questions to drop in. Again, thank you all for attending. I'm gonna wait just a minute before I thank you to see if there's anything else. Okay, we got another one. Okay, so the question is, I'm gonna maybe make this a little bit more general if that's okay. But if there is a food item that is at the table and a public official takes it home, does that give rise to a problem under the gift rules?
Potentially, yes. The food items need to be for immediate consumption only. So if there's something offered with the intention they can take it home, the gift rules might come into play and it might be a violation if that's occurring.
Yes. Yep. Great question. We get that question a lot from individuals who are hosting events, hosting engagements, educational private and social educational events throughout legislative session. We do get that question frequently. So thank you for asking that one. So the next one, we have one other question, and that one is during an advocacy event at the legislative session, like Disability Awareness Day, is the swag offered considered a gift? So I'm going to actually table this one because this is a little bit more of a legal, we've got a little bit more analysis and there's more facts that we need. That's pretty fact dependent question. Is that correct?
Yeah, if you have a direct question, maybe if you wanted to give examples of what the swag is, go to our website and consider submitting an advisory opinion if you would like that analyzed for
Yep.
you.
Not everything is treated the same.
Yeah,
So
especially if you're trying to host something at this upcoming session, that'll give the commission time to weigh in
there you go.
beforehand.
Fantastic. Well, everybody, thank you for your questions. Thank you for participating today. Thank you for attending all of the Ethics Commission's Dakota Dilemmas webinar series this year. We hope to be back in 2025, probably not during legislative session because we will be busy. Thank you all for attending again. We wish you the happiest of holidays coming up. And we hope that you all make it on Santa's nice list and not the naughty list. So thank you again. Have a wonderful Wednesday.